Hannes Westerman, Research Assistant at the Cyber Justice Laboratory at the Université de Montréal. Thank you for joining today's webinar, Exploring Compliance Technologies for Privacy. For those joining us for the first time, welcome. The Cyber Justice Laboratory is a research center that explores the interplay between new technologies and the law. We're currently conducting the project Autonomy Through Cyber Justice Technologies, funded by the Competition of the Social Sciences and Humanities Research Council of Canada. Our project brings together more than 50 researchers and 45 partners dedicated to the use of technologies and artificial intelligence for the prevention and resolution of conflicts. Over the coming weeks, the Cyber Justice Lab will be hosting a series of online activities that will gather the opinions and experiences of legal experts from around the world on the recent events. From ethical issues to crisis management, including analysis of the achievements and failures of technological shift in the legal field, the laboratory will present varied and relevant content. Stay tuned by checking our social networks and visiting our website, cyberjustice.ca. For today's webinar, we have the huge pleasure of welcoming David Restrepo-Amariles from HEC Paris. Thank you for being here, David.
Thank you. Hi.
The way this will work is that David will have his presentation. After that, I will ask a few questions, and then we'll take questions from the audience. So feel free, as I mentioned, to ask any questions in the Q&A field below. David, over to you.
Thank you, Hannes. Thank you, everyone attending this webinar. So I will start sharing my screen right now with all of you. Here it is. Okay, so maybe just a brief word of introduction about myself and my work and how it is related to compliance in privacy technologies. So first of all, I'm an associate professor of data law and artificial intelligence at HEC Paris, and I have been conducting projects on artificial intelligence and other types of technologies for the past 8 years, both industrial projects with corporations, but also research projects linking policy and research with organizations around the world, and especially in France with the Cour de Cassation, in Europe with the European Court of Justice, and also in Latin America with the Inter-American Development Bank. In most of these projects, really, we have looked at how to implement technology, in most cases from scratch, to improve some of the legal processes that were already in place. Now, actually, my area of research is a bit broader than privacy technologies, and I've also been working more on issues related to contract management in general, to decision-making in general, and also taking into account legal aspects. And most recently, in the past 2 years, I have worked in privacy technologies, specifically with industry partners. Well, I will keep the names of the industry partners silent during this presentation because there are some of these issues might relate to the work we are conducting. So let me just start by a topic that is very close to all of us right now, which is contact tracing apps, to introduce this subject. As you probably know, Apple and Google are launching an API that is being used by governments and national companies to develop local applications to trace contact in the different locations. Now, Google and Apple have made it clear from their perspective, although this is debatable, that privacy protection is one of the key issues to ensure the adoption of these applications in APIs by the public. Now, this was in May 20. The technologies, as you probably have heard, use different type, the API and applications use different type of technologies. And one of those that has been very much on the focus of discussions is the use of Bluetooth. And the collection of the data, then it depends how the system is organized, whether in a decentralized or centralized system, both using databases in a different way. Now, what is behind of these projects to some extent are chains of contracts, and more importantly, group of corporations that are collaborating with government and research institutions. So just to give you an example of what is going on in France, you have, in this case, at least 4 institutions that are collaborating in setting up these applications. This is INRIA, which is a research institution, and mostly working on issues related to technology. There is the ANSSI, which is related to cybersecurity. It's in charge of cybersecurity for this project. A global corporation is Capgemini, who's actually dealing with the back-end architecture and development. INSERM, who is doing all the sovereign data infrastructure, and other type of companies, probably you know Orange, and also organizations from the government. Now, what is interesting in this team is that it has more than 100 people involved in different areas and in different locations, although the application is developed in France. All these organizations are to some extent contributing to one single product. And for that, it is necessary, of course, that all their developments are able to connect. And this involves at some point sharing some data. And this is precisely the issue that is bringing us together. It is not only about privacy in itself, but about privacy in chains of contracts. So the outline for the rest of the presentation will focus on 3 areas. First of all, what are the issues related to data protection in chains of contracts specifically? I will share with you some technology choices that we are implementing in our project. So this will not be a broad discussion about technology choices in general. This will be, of course, too broad for one or just the subject of one single webinar. So I will share with you some of our experiences with the smart contracts blockchain and some of AI methods. And then I will talk to you about private tech, which is also a solution we have implemented in precisely dealing with these issues of compliance in chains of contracts. So first, in relation to data protection and chains of contracts, this is the outline for this part. Let me start with chains of contracts. What are we talking about when we talk about chains of contracts? Well, today, independently of whether the relationship between a client, that can be a natural person or a company, is data intensive or not, in most cases, it has some content related to data. Either some data is shared, some data is required to perform an activity, or some data is being used or collected by a company. So when you have a relationship between a client, in this case, as I said before, a natural person or a company, with a supplier, which is in the top of the chain, there is behind that several subcontractors also providing different supports or activities for the company that is in top of the chain. And this type of subcontracting can go in many different directions. Imagine you have someone that is a company that is providing digital transformation to a client. So it's providing online sales channels and improving their reach to consumers through different technological tools, including development of application, a website, and online offers. Now, this company that is providing this solution might have subcontractors all throughout the world, which are identified here in this part of the chain. These subcontractors can be at the same time large companies, can be individuals or consultants, and can also be other type of multinational companies. And those activities can go, for instance, on the bottom of the graph, you see, for instance, storage, right? So imagine that some of the information that is required for the digital transformation necessitates the storage of information. Now, it is very likely that the company providing directly the service to the client is not storing itself the data, but is requesting someone else to store it on its behalf. It could be, for instance, Microsoft or Google, or they might have their own servers somewhere else, but administered by a different company. It could also happen that they need to produce data analytics, which are not produced by the company itself that is providing the service. So they might outsource the data analytics to a different company that is located somewhere else, which in themselves use subcontractors. Now, it can also happen that the company at the top of the chain has other companies in its organization, so subsidiaries that are located in other places of the world, and those companies are also performing certain types of activities. Of course, this responds to a certain complexity in the organizations of contracts in general, and not only contracts related or containing some element of or some data. So in handling these chains of contracts, there is, of course, certain flow of data. But most importantly, as I probably just already underlined, is that the relationships between these different organizations is framed by contracts. Now, a first challenge when you see these chains of contracts is the heterogeneity of the types of documents that are linking those institutions. So of course, there is a contract cycle that we need to look first. And in most cases, companies start with information. So this is acquired information about a potential client or subcontractor. There is the negotiation of the contract. There are pre-contractual documents as non-disclosure agreements, for instance. There is the contract as such, and there are other types of documents executing the contract, and eventually, if it is the case, providing for dispute resolution. So there is, in this contract cycle, different types of documents are produced. And these types of documents go from information request, pre-contractual documents, as I mentioned before, main contract, data protection documentation. So this is where we are just right now moving into data protection issues. There might be privacy policies. So if you are, for instance, the example I provided before, you are providing for a new website on a digital transformation strategy, you might need to look at the privacy policies of the website itself, but also of all the companies that are being redirected from the website. Any due diligence documents, processing instructions. So these are the instructions that are provided from one company to the other. Processing audits. This is verifying at some point that the obligations are being complied with. Data protection impact assessment. This is the language of the European General Data Protection Regulation, but in general, data protection impacts. Another complexity of the chains of contracts is that documents are in very different formats. So they can be from PDF, spreadsheets, emails, letters. In the old world of the law, we still use letters. Word docs, scans, zip files, audio, and others. And lastly, in the related to heterogeneity of contractual artifacts, there is, of course, all the documents related to executing the contract, but also cascading those instructions that at some point are received. So this is all what is related to the execution of the contract. Going a bit more general at this point, another of the three types of challenges in chains of contracts are a general movement that we've seen in the past 15 years for compliance systems. And this was very much led by corporate social responsibility, which is basically the idea that companies that are on top of the chain should verify or at least are in some way accountable vis-a-vis consumers for controlling their supply chain. And this is, of course, not only in relation to an societal expectation, but it's also related to judicial accountability. And this, there is this famous Kasky case in the US, in California, in which consumers held accountable companies for the way they were organizing their supply chain and advertising the last products that were produced, although the supply chain was not located in the United States. Also, there is an increase in accountability due to monitoring tools like labels and indicators. And also there is a clear shift in priorities to some extent in locating compliance and respecting the supply chain as one of the key elements of corporate performance. And this, we can see it, for instance, with the emergence of non-financial reporting as an obligation in many jurisdictions. Last point is the complexity of the supply chain. The complexity because, as we said before, it uses different documents. There are many actors, documents in very different formats, but also that they are transnational, meaning that most of these actors attempt to organize their relationships through contractual documents. And another point, of course, is the increased support that compliance systems have within corporations. In one of the studies we conducted at HEC a couple of years ago, we identified, for instance, that in the banking industry, nowadays, 1 out of 10 employees has compliance functions, whereas this was about 1 in 1,000 employees before. So there is a huge increase in compliance functions, and although in some corporations compliance and data protection are kept separately, the mindset of compliance is very much framing the way data protection should be handled. Now, still in the first part of this presentation in relation to data protection and supply chains is the increasing role of data in business relationships. So on the one hand, we have contracts and chains of contracts. And on the other hand, we have an increasing amount of data that is flowing through those chains of contracts. So in most cases today, when we look at contractual chains, we have some specificity, which is that those contractual stack, if we want to use a tech term, that contractual stack contain specific documents related to data protection. Again, not only because there is more regulations, but because there is more data flowing. And an important part of that data that is flowing comes from customers. And this is one of the key elements that we have identified in ensuring compliance in supply chains, data compliance in supply chains, is that this data ultimately is the data of someone, in case it is personal data. So the supply chain, although starts probably with the data processor at the top of the company, in contractual terms, there is ultimately a consumer or a natural person whose data is flowing through the chain. So that's also an important element. And that data, it's vital for companies across the chain. So there is a natural temptation and opportunity for companies to seize that data and use it for their own benefits. So on the one hand, we have an increasing amount of data that is required for some activities, an increasing interest in that data, and an increasing flow of that data in the contractual chains. So here the question that we are addressing, of course, is how to ensure that there is compliance through this chain, given an increasing interest in using this data. And of course, the increasing number of actors that are in this chain. So if we look at specifically data protection in supply chain, there are several aspects that highlight the importance of this issue. First, of course, as I just mentioned before, is the large amount of data that is flowing, but also something that has radically changed, especially with GDPR, but also with the Consumer Privacy Act in California, is the liability that the main processor has in ensuring compliance throughout the supply chain. This basically means that the initial processor, the one that is gathering the data, so just apologize, but I will just go back to this graph. This means that this initial processor that is at the top of the chain becomes liable for all the processing activities that are being performed throughout the chain. This is quite different because, of course, one of the key elements before was that companies were unable to audit to some extent, unless it was contractually agreed, to audit the data activities that were performed by corporations or subcontractors. Now, however, they have the obligation to do it, otherwise they are held liable. So of course, this opens the possibility for companies to design instruments that allow them to audit that chain of contracts. However, it is not always easy to detect and manage risk of non-compliance in these chains of contracts, because of course the processes, as this is a very recent shift, are not designed to ensure transparency through the chains of contracts. And in most cases, companies will refuse to allow access to audits, that's very simple. I mean, if you have, in the example I provided before, if you are storing your data with Microsoft, Microsoft might not want to provide information about how it is handling the data, because it's not only handling your data or storing your data, but it's storing also the data of other clients. And this, of course, also raises cybersecurity issues if they are providing direct access to their servers for auditing. So there is, on the one hand, legal challenges, but on the other hand, there are also these compliance and operational challenges. Now, from the contract management perspective, this is an interesting point. Now, the fact that this is a privacy issue, or at least related to privacy laws and data protection laws, does not prevent this issue from being clearly a matter of contract management. We can see the compliance with privacy regulations as a new issue within contract management, with takes, of course, sufficient relevance as in some companies to be detached from the legal department. So of course here, what happens is that although these can be seen as part of contract management, operationally, in many companies, it does not belong to the same service. And this is bringing one key problem, which is a database issue. What I mean by database issue is that all the chains of contracts that are organized or that are part of the execution of one single contract between a processor and a client are not located in a centralized database in many cases. I can tell you, well, this from several industrial projects we are developing, but several very big companies actually have problems locating where their documents are. And this is totally normal because, of course, sometimes they are local contracts, and some of the subcontractors are actually pre-exist a contract with the client. For instance, a company has a subcontractor for storage, but this is a general subcontractor. It means it is not related only to one specific contract. And in many cases, this is not handled by the same team. There might be a team that is dealing with procurement, for example, and other teams are dealing specifically with data protection issues. So what you have here in contract management is the silo structure of corporations that makes this difficult. On the one hand, data is not centralized, which is a clear issue if you want to implement any technologies for checking compliance. But on the other hand as well, you have different departments dealing with different aspects of the chains of contracts. And lastly, but not least important from a contract management perspective, is that because the organizations still work in silos, they might not be using the same softwares. So it is not so easy to develop plugin applications into one software because you need to ensure that there is some coherence in the softwares that are used. And it is not easy, of course, to just start a new software from scratch or adopt a new software, because this is a very costly operation. Now, the last point before moving into the technological issues are related to the consumer protection aspects. And this is actually very important because, as I mentioned before, the data flowing through chains of contracts, unless it has been anonymized, is the data of someone. Of course, a company can decide to use only aggregated data, but in most business models, the data you need is data about a consumer, especially when issues relate to marketing. So because this data relates to a consumer, and consumers have been granted additional rights and protection under privacy laws, especially in Europe and in California, but this is the trend that is going on elsewhere. Companies need to implement systems that allow them to respond to queries from consumers. Now, of course, it is very easy, let's say, in some way, to at least organize your own house, meaning to ensure that when a consumer asks for the deletion of certain data, that it is deleted from your server. The problem here that we have is, remember that we are in chains of contracts, which basically means that your data as a consumer might not only be in the database of the company with whom you have directly entered into a contract, but in the servers of all the subcontractors as well. So how can actually the company ensure that this data is deleted in the servers of all the companies participating in the supply chain? So this shows the extent of the challenge of ensuring the compliance, or ensuring the respect of rights of consumers. So here comes a very simple idea, which is that although a lot of privacy discussions and discussions focusing around how to protect consumers exclusively look at the relationship between a consumer and a company, we think in some of the projects that we are running that to ensure proper protection, you definitely need to look to the chains of contracts. It is not enough that the first company says we have deleted your data if all the other 10 or 15 companies involved in the supply chain are keeping your data in their servers. So this is basically how we are conceiving the challenge. So this takes me to the 3 pillars of what we think is privacy compliance in chains of contracts. This is how we have been working with our industry partners, research projects, including, of course, cyber justice. So the first pillar of privacy compliance in chains of contracts is the coherence through the chain of contracts. This means that when company A has a subcontractor B, and B has a subcontractor C, and C a subcontractor D, we need to ensure that if the first contract between the company and the consumer said that the data needed to be deleted 6 months after it was used, all the chain of contracts provides for the same provision, which is not always the case, right? Because remember that, for instance, subcontractor C and D are not linked anymore to subcontractor A directly. So it could happen that at some point, subcontractor A does not, company at the top of the chain does not have access to contract of subcontractor C and D. So the first issue is, how do you ensure that the legal terms, at least related to data protection, are coherent through the chain of contracts? Second pillar of privacy compliance in chains of contract is ensuring compliance with regulations. This means that this means verifying that every contract, so the first is verifying coherence through contracts, and the second is verifying the compliance of contracts with regulations. So how do we know that, how do we ensure that contract of subcontractor A and B complies, for instance, with GDPR, subcontract of subcontractor B and C complies with GDPR. So there might be terms in these contracts that may not be compliant. For instance, imagine that contract C and D foresees that some data is transferred to a jurisdiction which requires additional safeguards under data protection law. And these safeguards are not provided in the contract, or are not provided through other mechanisms. So this might reveal that subcontractor B and C have a contract that does not comply with privacy regulations. So the second pillar of privacy compliance in chains of contracts is checking compliance of contracts in the chain with privacy regulations, both from the country where the top company on top of the chain is located, which is ultimately liable vis-a-vis the consumer, but also checking compliance with local laws under which the company is operating. Last point is auditing and verification of effective compliance. Now, this is a really tricky issue, and to be honest, is the one that we have worked the least in our team, although we have several attempts in this area, because this third point is nuanced, should be nuanced at least. One element of verifying effective compliance, which is a very an approach that lawyers like a lot, or tend to trust a lot, is self-reporting. Meaning company C might just say to company B that they have deleted the data. However, there is a further verification, or they want at least a document from company C saying that company C deleted the data, right? This is a document that has a value in the contractual chain. However, you might go even farther, which is to verify whether the data has been deleted in the server. So this is a more operational dimension of the auditing. So in any case, this third pillar relates to auditing and verification of compliance. So this is, in brief, the summary of how we can view compliance in this area. A last point, sorry, before I move into, it is very, very short and also more based on our recent experience, is how do you bring a project about privacy compliance to run between different actors? Now, this is a tricky issue. First, because there is clearly organizational challenges. I explained that before, meaning the person who might be a contact in a certain department might not within the same company be able to ensure that all the dots are connected within the company. So there is a clear expectation, there's clear different expectations in different departments. Now, one additional point that seems to be often neglected has been neglected by myself, but is often neglected by those proposing a technology solution, is that using a technology means to some extent reorganizing processes. So it is not just about implementing the solution itself, it is checking it sometimes, as I'm going to give you an example later, whether a certain document that is used should not be split into two, or whether the responsibilities for a certain task should not be organized differently or across departments. So it can happen that the implications on the way processes function are underplayed when a technology is deployed, which might ultimately play against the adoption of the technology by those needing to use it. A last point, two last points, which is on top down and bottom up, and academia and industry. So there is a classic question when these instruments are deployed in organizations, in companies, but also in law firms, as to whether this needs to be a top down or bottom up. And I guess the answer is it's a middle up and middle down. And in the sense that you need top support from the top for such a solution to be deployed, because as I mentioned earlier, this entails to some extent reviewing current processes and organization. But at the same time, you need this to be bottom up, because you need people to grow with the tool rather than requiring adoption of the tool. You need the people concerned with the tool directly to grow with it, but also adapt it to their needs. So I guess the best way of moving forward with these issues, especially as they concern data and concern, in many cases, data protection officers, is that there is support from the top, but the project is led from the bottom. The role of academia in this, should you go together or not? And I guess this is to some extent controversial for those that are that seen the evil in technological solutions in the legal industry, saying, well, once you start implementing the tool, this might have a backlash or might backfire. But the truth is that from the academia perspective, we need case studies. Some of the theories and tools that we are developing and some of the learning that we are doing relies sometimes on a very small data set, on always on the same types of data set, or does not take into account the entire process that is required for a tool to be deployed. So there is a lot of things to learn from the academia perspective when you work with industry. Now, let me move now to technology choices, and I'm just looking at the clock right now. So technology choices, which is the second part of the presentation here. So technology choices organized, I'll just focus on the three first points, which I think are the most relevant. So first thing is, how do you choose a technology to ensure privacy in your chains of contracts? Now here, there is no one single answer. There is no one size fits all answer for these. And I would say there is different ways of looking at it, but the way I would look at it is in terms of maturity of the company or the organization that is adopting the technology. Again, a technology is not an isolated tool that is deployed. A technology is a tool that connects to an organization. So what technology is required, it depends to a certain extent of what are the capacities and capabilities of the institution or organization in which you are deploying the tool. If you look at these, this survey that was organized by the Boston Consulting Group, looking at how companies see themselves and what capabilities they have in terms of an AI strategy, you see, for instance, that Passive, which is an organization with no adoption or much understanding of AI, is 34% of the companies responded that they were passive in terms of AI, although they recognize 39% that AI is key for their strategy. Now, the question here is it the right path forward to immediately deploy a complex AI solution in a company that is in the passive level of this scale, when the company has no adoption and no understanding of AI? So again, if you look at companies which are pioneers, that companies that both understand and have adopted AI, these companies, which consider 85% of them that is AI is key for their strategy, it might seem natural that a company like that could adopt for privacy compliance a more complex technology that involves, for instance, training or developing their own algorithms, whereas maybe an experimenter would just adopt some sort of, or implement some sort of automation in their process rather than a full AI solution. So how do you choose a technology? And this is my only point at this level. I would say that a key element is look at the maturity of your company to implement the technology. A technology is not just at the level of buying it and implementing it. You have to maintain the solution over time. You need to scale to other processes. You might want to connect to other tasks, and you might need to expand, for instance, at some point a language. So if you don't have those capabilities within your company, or if you don't have a good contact point between your company and company to which you outsource these tasks, the technology might not be adapted to your organization. Now, in our work, we have deployed mostly smart contracts and a couple of methods of artificial intelligence. Now, it is not an easy task, though, to implement smart contracts. It has been argued to some extent that smart contracts have certain clear benefits over other technologies for verifying any of the three pillars I mentioned earlier: coherence of contracts, compliance with regulation, and audit of effective compliance, right? We are looking at these three pillars. So smart contracts, one of the advantages of smart contracts is that data protection rules have been detailed and are, at least in the context of recent regulations, have been laid down in a way that are relatively specific and using a very specific language, which seems to facilitate to some extent that some of these obligations are transformed into a computer software. So it seems that if you look broadly at the different fields that are related to contract management, data protection rules seem to be one of those that are more fit for smart contracts. Now, the other issue here that is relevant is that because Data protection has created the obligation, the accountability in the chain, and smart contracts allowed to monitor easily through the chain and store this data at a central level or not, depending, but at a verified at central level. It provides access to all the parties involved to a notification of compliance. Now, one of the difficulties we have identified with smart contracts is, of course, the lack of flexibility. If you are aware of the situation with the COVID-19 in terms of contract management, most companies have renegotiated delays and performance in the current situation. Now, if you have automated execution, of course, you can withhold the execution of certain obligations in the contract. But if you need to recode the renegotiation of the contract that are being performed, this might be challenging for an organization and discourage them from adopting smart contracts. So there is a lack of flexibility that has become evident with COVID-19. Let me just keep the other two for the examples. And I will jump this one. So how do you implement, what would the process for implementing a smart contract for privacy compliance? So what we have done, this is very much inspired on what we have been doing in the last couple of years. The first thing we run a feasibility analysis. This means that we take documents that are connected. I mentioned earlier the type of documents that you can encounter in privacy, in the supply chain related to privacy. So we do a feasibility analysis, which is which of the clauses or the purposes in these contracts could be converted into formal language, can be formalized, and which ones cannot. And those that cannot may not be for several reasons. One, because it requires a constant reinterpretation of the clause, but also because it just does not contain a clear obligation. It might just be a definition. So a definition of what a contract is, you don't need to formalize that. So what we see in this feasibility analysis is that some of the clauses that do not contain the execution of an obligation, for instance, well, to some extent does not make sense to be converted into a smart contract. So what happens is you end up with a mixed solution, meaning part of your contract can be converted into the smart clauses, let's call it like that, and some will remain in the original form. So you need to design a solution at the operational level that allows you to have both running at the same time. A third element that you need is to select a specification language. And I will give a concrete example of the specification language in a second, but this is basically what allows you to convert the natural language of the document into the code, right? So you need a language that provides for the elements that are required in the contract. For instance, you have a clause on data deletion or data retention, right? So the objective here is to determine the timeline in which you have to delete the data. So the specification here is first an obligation of deleting the data, and what you are looking is for the timeline. So you need a language that allows you to operate these specifications. Now, to some extent, these specifications are specific to privacy issues. In our case, we started from a language that is called Symboleo, that is developed by the University of Ottawa, with some of our colleagues in the ACT project, and we have expanded the language. So to make sure that these will respond as well to privacy, specificities of privacy and data protection regulation. Now, what we do then is we cross-match of documents. So we review individual documents. We annotate based on a domain of ontology for contracts. So in this case, what I was just saying before, a domain ontology allows us to look a document drafted in natural language in categories that can be transformed or formalized, such as obligations, powers, assets, right? So that allow us to identify those areas of the contract, and then to formalize it into the language to do the software development, implementation, and auditing tools. Let me give you an example right now what I'm talking about. So what we have here is we have a natural language contract, which can be any of the documents on top here, which can be any of the documents that are part of the contractual stack with the companies. And then you use a specification language. As I mentioned before, we are using Symboleo in collaboration with the University of Ottawa for most of our projects, which allows them this process to expand and to identify whether the language needs to be redefined. And once we have this specification language, before running the smart contract in the blockchain, we do a verification simulation. This basically means that we verify whether if there is a clause providing for the deletion of data, right? And this deletion of data generates a notification to the company on the top of the chain that when this data is deleted, either self-reported or, for instance, verified through IoT or through a message in the server, for instance, that it generates the notification, right? So we verify that whenever the condition is fulfilled in the contract, the consequence is executed by the contract, and this before actually it is run on the blockchain. And then I'm not going to go into the since I'm running a bit out of time now. I'm not going to go into the specificity of linking or not the contract to the blockchain, but I will say a word in a second about that. Now, this is an example of the formalization that is required. And this has been one of the most difficult issues that we have faced in most of our projects. Because basically what we look here, this is a very simple obligation, right? In which, for instance, X, which is the debtor, shall maintain a record of categories of processing activities carried out on behalf of client regarding the services provided under this agreement. So the first thing that we have to identify in this case is which is the obligation that we are going to code in the language. And here it's the obligation is to maintain a record, right? And who is the debtor of that obligation? The debtor of that obligation is X, who is the one that has to maintain a record. And the one that is a creditor of that obligation is the client. Now, the asset that we are identifying is the record of categories of processing activities. So the obligation is to maintain the record, and the type of record is of processing activities. This is the type of formalization that you need to do through the language. But however, this is just too simple to be real, because what comes next, this is based on a real contract. What comes next is what are the features of that record? And in this case, what we have is that the asset, which remains the record of categories of processing activities, has different features. That feature, for instance, includes international transfers as a processing activity, and that international transfer itself has some other conditions, such as, for instance, we need a description. If you look at here, this is the contract itself, where possible, a general description of the technical and organizational security measures implemented. So here again, we reach one of the limits of the formalization through the specification language. But we can, however, register that as a feature of the asset that we have identified in the formalization process. Let me now jump to the second part of this. Let me just control time here. Okay, I will just go for a couple of more minutes. So we have identified the possibility of using NLP in conjunction with smart contracts. So what would be the purpose of using NLP in this case? Well, in this case, when you have what you have on the right is the contract in the formalization that is required for the smart contract to operate. So if you look at the content of the contract, what you see is that we need certain information to complete the smart contract. For instance, if you look at the first part, seller shall sell an amount of, this is kilograms of meat, right? And with certain types of qualities. So what we are looking at this stage is how to extract through natural language processing these information from existing contracts so it can be introduced into the smart contract. Now, this is fundamental for one simple reason, is that if you look at chains of contracts, they include, in some cases, hundreds of documents, meaning that in some cases, it would be difficult to code these manually, and many organizations will not be willing to shift to a smart contract solution if they have to code everything by hand. So the NLP is an interesting solution to connect the existing natural language documents with the smart contract. Last point is one of the documents that is concerned by the privacy compliance in the supply chain in relation to privacy is privacy policies. So one of the softwares that we have developed for the moment that is called Private Tech, and I will show it in a second, relies on the one hand, machine learning, and on the other hand, on a rule-based system to identify categories of data processing. So this basically looks at the document, in this case, a privacy policy, to identify the type of processing activity that is taking place. And once this category is identified, we applied a system of rules to check whether this processing activity is in compliance with GDPR in our case. So if you have a look here, we have a data practice, which is for first-party collection of data. Down here, this is the rule. Then the personal type of information is cooking and tracking elements. The purpose is advertising of marketing, but the choice type is unspecified. So it has not been provided, which for us leads to a breach of GDPR. So this is the second part of the analysis, which relies on a first part, which is the extraction of the data processing activities through machine learning. This could also be done, for instance, by using simply a key phrase extraction. This is a more simple way of identifying a data category, processing category, but it can also be done through machine learning. So what we have done for the moment is we rely on this user privacy data set, which has annotated data from different privacy policies to train our algorithm and identify the different data practices. These data practices have certain attributes, as I just showed it here, right? Like personal type of information or purpose. And with these data attributes, we'll link them to GDPR to generate the rule-based system of verification. So I will just finish with, this is my last slide. I will just finish with showing you how this looks in practice. So let me just give you this example here. So if you, this is now, we are in the front end of the application. So if we go, for instance, into, let's go into this one. These are privacy policies that are verified by our software. And what you have here is, on the one hand, you have the entire document highlighted in different colors. You are seeing the privacy policy, right? Just want to make sure you're not on the slides. Okay, so you see the different paragraphs are highlighted in different colors, which are related to different types of data processing activities. And if I go just first, this one here, it just takes me to this place, and it says, well, we may change our privacy policy, so please check this page from time to time as your continued use on the online services after we publish our changes. So what does our software identify? So first, it identifies a data practice, which is policy change, right? And it says notify the data subjects of a privacy relevant change is part of the transparency principle, which is contained in GDPR. So what's the recommendation? Make sure the data subjects are properly notified about the privacy change with the possibility to choose when relevant. So we think, according to this software signals here, that this paragraph is non-compliant with GDPR because it's not notifying the user, but it's asking the user to check the privacy policy. Now, a last feature, and I finish with that here, is the readability score, of course, you can go that through different policies. The readability score, for which we relied on the Flash Kankade algorithm to check on readability. And if you look at here, the score of this privacy policy is 12. Now, 12 is extremely low because the scale goes from 0 to 100. And Article 12 of GDPR requires that an article is clear and easy to understand. The privacy policy is clear and easy to understand. And we have, after several tests, identified that a readability score around 70 would match the standard required by GDPR. And here we are at 12. So this is particularly slow. So that's basically the end of my presentation. I'm sorry I went a little bit over time, but I'm happy to stay longer as well for any questions that you may have. This is the different persons involved in these specific projects, which are privacy compliance in chains of contracts, our team at HEC, a team in École Polytechnique in France, in Ottawa, Daniel Amiot, who's developing Symboleo, and Ken Sato, who's working on a ProLeg as well. Thank you very much.
Thank you so much, David. I thought it was a fantastic presentation. I certainly learned a lot, and I thought you did a great job of explaining the difficulties with checking compliance in chains of contracts. When I think of privacy, I usually think of one company, but I think it was a great to see here how many companies are involved and how difficult this makes compliance in terms of the interest in this data and the difficulty for all the actors in complying with the different regulations. So next, I have a few questions about this that I'd like to ask David, and after that we'll go to audience questions. I've seen there are some questions already, but keep them coming so that we can get to those at the end. My first question is, this seems like an extremely useful and a very valuable project. So I wanted to ask, what would need to happen for this to be implemented in practice? How do you get this to work at scale between different companies?
Yeah, that's a very good question. That's a very good question. And well, I mean, you have right now a solution that is called a One Trust. That it's paradoxically, it's a startup. I think it's based in California, and that has become quite dominant in the European market by providing a solution to comply with GDPR. So to some extent, this shows a little bit how difficult it is for sometimes local actors to develop and scale solutions internally. And I think that in practice, the way this happens is you need certainly a company to some extent at the center of the supply chain. So you need a company that has a data-intensive organization, a data-intensive business, and that it has different companies around its operations. Now, this is just on how do you ensure that other parties play by your rules. So to some extent, I mean, this is imposing, of course, your standards on other companies. On a more consensual and maybe internal from an organization, this is definitely very challenging. I don't really think I have an answer for it. I think important for what we've seen, we have run several industrial projects in the past years with large companies, mostly European. And what we have seen is that you really need a team leading the project inside. And you need the keys to different areas where the information is located, where the decision makers are. And very important, you need to ensure that the operational people are on board. In many companies, you have already teams working on AI. The only issue is that AI is part of their business, but they are not developing AI for their company. So in some cases, you have paradoxical situations in which you have company with high expertise on AI or people or a service with high expertise on AI, but that is not used internally to improve legal processes. So I guess that one important thing here is how do you get these people on board in these sort of projects?
Right. Okay. No, I think that's a really good answer. And that brings me kind of to my next question. How many people do need to go on board for this to work? Like, does it require several companies to be involved, or could it work if only one actor adopts the system and then scale up from there?
So how many people, you mean how many people in within the organization?
Yes, so more like does it require for several companies to all adopt the systems immediately? Like, does it depend on networks effect like this, or could it work inside one organization?
Yeah, well, I think, yeah, that's a good point. I think it can work within one organization. Of course, it depends on the scale at which you are looking at. But I mean, if you take a law firm, we have done this with several law firms, very large law firms, and we thought, well, let's work only with one office, let's say with the Paris office. And actually, it has worked pretty well. I mean, as far as the task is properly identified, and the answer matches to some extent their needs, it can just stay within one organization. However, I think the interest of compliance system in the supply chain is that they can go beyond, of course, one organization, and that's where everything becomes complex, because there is not only security, but this is a key issue. When you imagine that there is auditing, there is a key issue, which is to ensure that there is no security flaws, and the other part is how this changes in general management and operations, also in the other organizations. So I don't think you need a very large team to do this, but you certainly need a team that is involved in the flow of the data, or in the flow of the contracts, and not just one that has a task that is purely internally. If you're targeting the entire supply chain.
Thank you. Okay, great. So that sounds really promising. So next I want to ask about different types of blockchains. I know you could use a public blockchain or a private blockchain. I want to ask kind of what you had considered to use on this project and why.
Yeah, so good question. I mean, so there is still controversy within our researches. I guess the public blockchain makes sense if you really need auditing, and you really need a decentralized system in which data is information data is shared and audited. If it is implemented within one organization, at this stage we don't really think a public blockchain is required. But it remains also here again an issue of to what extent you want to keep control of the processes. And I have to say that at this level, we have encountered a lot of resistance for public blockchains in the organizations we work with, although they do have expertise with blockchain.
I see. Yeah, that's one thing I was thinking about as well, that companies might be worried if the contracts become registered publicly. So I want to ask more, like, are people worried about this and their trade secrets getting out via this public system?
Yeah, totally. Yeah, definitely they want to keep their contracts very private. I mean, this is one of the competitive advantages, of course, when you negotiate contracts. But even beyond that, I guess is to what extent you keep really control over your processes. And I mean, moving to a blockchain technology is a huge step for a corporation, and it's a huge investment. I mean, even large banks are hesitate to move in certain processes, including related to cryptocurrencies and crypto assets, into the blockchain. So it is even more relevant when we are talking about checking for compliance in chains of contract, which is, I think, especially if we are in pillar 1 and 2, which is not on the ground auditing, I think the public blockchain is a bit too much it goes beyond what is really required. And I'm not sure to what extent companies are ready to move to auditing on the ground. I mean, this is an issue of to what extent, and I think it is desirable from a transparency perspective, but to what extent does a company in the middle or on the top of the chain wants to know whether the subcontractor, which is Microsoft, has not deleted the data of their client, and for which they cannot do anything and the client doesn't know. So this would, of course, improve transparency for everyone, but I think companies really will feel they are not in control of their business process, especially as, again, I feel at this level, we are not on the auditing or at the operational level. At the best case, we are on a self-reported auditing.
I see. Thank you. That was very interesting. Next, I want to ask from a bit broad perspective. So, as you mentioned, GDPR is entered into force in Europe, and in California there are similar things. And it seems like many companies are seeing this as a significant burden to their operation, and perhaps to start new operations as well. So, my question is: do you think technologies like this could play a role in alleviating this burden?
Yeah, that's exactly how we started working on this. Is that there is a clear burden, especially with accountability, meaning companies have to document. Companies have to verify and document their processing activities and the processing activities of their subcontractors. And I mean, the truth is that this is very difficult to do in practice. Companies are struggling to do it. Many supervising authorities have said they have used this expression several times. They are on a trajectory of compliance, but they have clear failures for compliance. And one of them that has been identified both by the ICO, for instance, in the UK, but also by the CNIL in France, is the change of contracts. You have made a lot of progress within your organization, but how about what goes beyond your organization? And I think this is a challenge for actually both companies and the regulators, because it's time consuming, resource consuming, and it's, again, for me, this is very personal, this is a key part of ensuring privacy protection for consumers, is that not only the company, which is in the front of the relationship with the consumer, is complying with regulations, but all the companies that are behind.
Thank you. Another great answer. And really glad that brings us to my next question, which is kind of the perspective of the consumer. I think people often claim that in blockchain systems, it might actually cause trouble for privacy compliance, since it's very hard to delete data on the blockchain, and which could conflict with the right to be forgotten. So I want to ask if you have any thoughts on this subject.
Yeah. So yes, I mean, deletion is a very interesting subject. So we have faced, even before getting into blockchain, we have faced very interesting issues, such as deleting the image of someone in a picture when there is other persons in the picture itself. So when you require that your data is deleted, but your data is intermingled with someone else's data. The same issue in relation to the access to information is the extent to which the data is mingled with other person's data. And this is not only when the database is public, let's say, or if it is in the blockchain, but even when the database is purely internal, a matter of locating the data and then actually deleting part of the information. And I guess if this is such an issue for databases that are entirely under the control of the company, it is even worse when the situation, when the data is, when the system has a connection with the blockchain. And clearly, the right to be forgotten has been called out by several experts as being a clear hinder to the use of blockchain in some of these processes, especially when we are talking about, I mean, there is systems like Hawk, I don't know if you're familiar with it, which are more really on the flow of the data itself. So I think that there is maybe a level at which I didn't went into this, because it goes beyond chains of contracts, in which I really wanted to focus now. But the other element is is the operational and technology that are being deployed at a different level, that are for tracking the way data moves into different organizations and servers. And these, at these more operational level, I think blockchain has been really identified with solutions like Hawk for exactly these type of elements. I don't know. I see there is some. I don't know.
Yes.
I see some windows popping up in my side. I don't know if I should address them or
no worries. We'll get to those very soon. And so it's a great point though. So I have one more question. After that, we'll go to audience questions. So don't forget to post your questions down there, and then I'll read them to you, David. So don't worry about it.
Okay, perfect.
So my final question is, you mentioned at the beginning and talked about the pandemic, and I want to ask a bit more about this kind of data, health data that could be extremely useful for researchers in finding a solution to the pandemic, but that also has a huge privacy risk due to the very personal health nature of health data. So I want to ask, do you see any issues or opportunities with using these kind of systems for that data?
Yeah, well, that's great, and that's as you know, Hannes, have been involved in this some extent in the past few months. I think that this pandemic has brought one group of technologies, or let's say like that, or researchers to the front that are very important, which are cryptographers. And a lot of the discussion around COVID-19 contact tracing applications, for instance, is about whereas the data we are collecting is personal or not, in the sense that if we cannot identify if it is not possible to identify the person, it does not qualify as personal data. And this is the role where the cryptographers are coming in, is to say, well, if we manage to use cryptography so that data that is communicated between the phones or to a central server does not allow to identify the persons. We, to some extent, lighten the requirements for regulations that apply, but also for compliance to some extent, right? Which is what we're concerned with. And I think this is, again, a very interesting solution at the level of how data flows through servers and devices. And that can certainly, that come more from an operational part, and that will have an impact on the way contracts will deal with this data at a second stage. So just to point at one specific example is that there has been some discussion as to whether when a central server in the centralized model of contact tracing collects a key, right, that has a key but does not have personal information, it is also capable of collecting the IP. So this is a key issue because, of course, if you have a key that is anonymized, then you might not be able to identify the person. But if with this you can also collect the IP, then it becomes personal information. And this is why decentralized systems have kind of gained a little bit of popularity in the current crisis, because the idea is to avoid that some sort of personal information can be collected. But this has happened before. I mean, in 2015, the Federal Trade Commission in the US had a settlement with a technology company, NAMI technology company, because they were using, when phones were looking for the Wi-Fi signal in stores, the stores have installed mechanisms to collect the MAC address of the phones. And they were using this to create heat maps in commercial areas to look at how consumers were moving through around commercial areas, like with Starbucks and other companies, so they could to some extent influence their behavior, or at least provide marketing and advertisement that were appropriate for their business. And these more operational part of the technology, I think definitely needs more attention. And I would say it's the next challenge of privacy compliance, which goes beyond textual compliance, because what we tend to look with these softwares, and I acknowledge that entirely, is that we are looking at whether contract A and contract B, for instance, are coherent, or whether contract B is coherent with regulation. But what we are less looking at is actual behavior and actual data flows. And this is the auditing part, which is way more difficult and that requires an enhanced operational approach. I think that was a very long answer.
That was a fantastic answer. Thank you so much. It sounds promising, but also like there's some very interesting work left to do as well. So those are my questions. Thank you so much for your fantastic answers. And next we'll take some questions from the audience. And I've seen that a couple have come in so far. I keep posting them if you want in either French or English, both are fine, down in the QA section. So first we have a question by Jaromir. With using NLP to extract certain elements of a contract, what is your experience as to the reliability of that extraction? What was the quality of the contracts you work with, i.e. did you have some OCR issues? And were the contracts fairly uniform or diverse? And what specific NLP techniques were used?
Thank you, Jeremy. Fantastic questions, and I have to say that some of them have prevented us from sleeping several times. Well, yeah. So first, actual access to documents and contracts. Again, difficult point here is the heterogeneity of documents. So one of the first thing is that we refuse to work with only with documents that were called contracts, because this is not what really matters for companies. An email sent by company B to company A, or let's say to a client to company A, saying, please keep the data for 6 more months. It's altering the contract. So it's a contractual, it's part of the contractual documents. So one of the real challenges, Jarman here, was first to identify to map all the documents that could be considered part of the contractual stack. So we like to use this expression, which is not just the contract, but the documents that constitute the contractual relationship, right? And once you have that, you have documents that are completely heterogeneous. And that's why when we started, actually, to be honest, in some of the projects, we never thought of using NLP. Smart contracts. It was Daniel Amiot who very kindly sort of took us on that direction. It has been really a fantastic path, because our solutions relied mostly on NLP. But however, we identified some of the weaknesses of NLP was that some of these the heterogeneity of documents and the quality of documents. So what we are working on now mostly is on using NLP to feed the smart contract, and we do have actually a quite large data set. So it depends on which of the projects, but in some we are on around 10 to 15,000. In other projects we have sort of a promise of, we have very few documents, about 100, but we have a promise of 2 to 3 million documents. So we are training on a small data set. And in other, we have a lot of documents, but all of them very different. So very challenging document. In terms of, I guess, because the question disappeared, but I think your other question was whether, what methods of NLP we've been using. So we've been using different methods. So we have word embeddings, bags of words, key phrase and keyword extraction. It varies a little bit depending on how the structure of documents. So yeah, so I guess this, hopefully that answers. I don't remember if there was one more, but I guess that answers hopefully to some extent.
Yeah, I think that was a great answer. Thank you.
Okay.
Next we have another question by Daniel, who I think you mentioned, Daniel Amiot.
Yeah.
He says, great presentation, David. As a follow-up, are there international standardization bodies that could be targeted or that are already active for PrivTech?
Yes. Yes, that's a good question as well. So we have been looking into. The answer is no. We have no one specific international standardization body that we have targeted for this purpose. And mainly the reason is that although the product is the software PrivTech is operational, especially at the rule-based level, we have on the machine learning part, we have had different sort of approaches and the extraction of the data categories that we relied right now upon are mostly the data categories used by the privacy project. And this privacy project that annotated the data based on data categories that are not GDPR. And so what the challenge we are facing for a full operation in compliance with GDPR of PrivTech, on the one hand, is that our data processing categories were done by American researchers based on somehow American conception of data processing, which are really great. And it shows that there is some transferability of these annotations to other jurisdictions, but we are missing data. We are missing, like, for instance, data transfers, which is included in GDPR, but is not a data processing category included in the annotations. So what we are working on at this stage is on improving the data processing activities category, based on GDPR regulation, and improving the quality, improving and implementing the machine learning solution for the detection of data processing categories from the text. Yeah.
Thank you, David. Another great answer, and really something that interests me in my research as well. But that concludes our program for the day. I want to again thank you so much, David, for accepting our invitation and this great presentation and answers. I certainly learned a lot. Thank you so much.
Thank you, everyone. Thank you, Hannes.
Also, thank you to the audience. For this week, this was our final live program, but we have many further weeks with interesting content coming up. So for the rest of the program of the summer, I encourage you to go to cyberjustice.ca, and there will also post the recordings for this week and some interactive blog posts. So thank you to everybody, and stay safe and have a great weekend.